Good afternoon. You're listening to the Emily Rooney Show. I'm Kara Miller, in for Emily Rooney, who I'm happy to report will return to her usual spot in this chair tomorrow. But today, we look at sex, harassment, and the law. In a televised press conference yesterday, GOP presidential hopeful Herman Cain vehemently denied that he had ever sexually harassed anyone, despite allegations from 4 separate women, 2 of whom have come forward so far.
There will probably be others, not because I am aware of any, but because the machine to keep a businessman out of the White House is going to be relentless.
But what constitutes sexual harassment? Do men in positions of power regularly reach agreements with female accusers? And are those agreements commonly sealed? 2 lawyers join us to discuss the definition, implications, and the gray area, if there is any, involved with sexual harassment. Then we turn to the case of legendary Penn State coach Joe Paterno, who just announced this morning that he will retire at the end of the year. What kind of obligation did Paterno and others at Penn State have in reporting the sexual abuse that they heard about? What went wrong in this case, and how should accusations against Jerry Sandusky be handled? Joining me to answer these questions are Kent Greenfield, a constitutional and corporate law professor at Boston College Law School. He blogs frequently for the Huffington Post and has just released his second book entitled The Myth of Choice, Personal Responsibility in a World of Limits, which we will actually get to later in the show. Kent Greenfield, thanks for being here.
Thanks. It's great to be here.
We are also joined by Ellen Messing, a partner at Messing, Rudofsky, and Wilicki, PC, an employment law firm that represents people who have been fired and victims of sexual harassment. She has also written extensively and done a lot of training on sexual harassment and the dynamics of leadership in the workplace. Ellen Messing, thanks for joining us.
Thank you.
Ellen Messing, I want to start with you. You know, you have heard these charges come out sort of drip, drip, drip over the past week or so. And certainly Herman Cain was vehement yesterday. But when you hear the allegations that we have heard so far from Karen Khrushchev, who works at the Treasury Department now, and Sharon Bialik, who gave a press conference on Monday, what runs through your mind?
Probably the first thing that runs through my mind is the incredible courage shown by these women in coming forward. Most sexual harassment is not reported. Most victims of sexual harassment don't come forward. Most people who suffer from sexual harassment in the workplace find themselves re-victimized when they attempt to solve the problem by reporting it or bringing it forward. So it is an incredible act in the usual circumstance for someone to come forward and tell their story in this way.
Kent Greenfield, I want to ask you to weigh in on what Ellen said. But also we saw, to add to what she says, we saw Herman Cain's campaign send out emails recently telling supporters that Sharon Bialik, who accused him of sexual harassment on Monday, has been involved in lawsuits and bankruptcies and a paternity case. Is this a sort of common way of fighting back?
It sounds like it. I think Ellen is right that the accusers who come forward, especially with regard to someone like Herman Cain, are showing a lot of courage. And the reason that this is sexual harassment law is such an important area of the law is it's not really about sex, but more about power. Right? It's usually the person in power, usually a man. Not always, but usually a man, asserting power over women in the workplace, and it's a way. Courts see it as a kind of sexual discrimination, a discrimination on the basis of sex, and because it's a way to subjugate and keep people in their pre-existing roles. So I think one of the reasons why we need law like this that punishes sexual harassers is otherwise. The pre-existing norms of gender norms will be very pervasive in the workplace.
And yet, you know, Herman Cain made some really interesting legal distinctions here. I want to play a cut of him talking about a settlement versus an agreement, and then go to Ellen. And Ellen, hopefully you can explain to us what Herman Cain is talking about here. Let's listen to him yesterday.
When the firestorm started a week ago Monday, I was presented with the accusation of some settlement was made. Settlement to me means that there were legal implications. Later during that same day, I then recalled, after all those years, that there was an agreement. That's what businesses sign with employees who are departing the company. They call it an agreement. Settlement implies legal implications. All of the potential legal implications or ramifications or accusations were found to be baseless.
Ellen Messing, a partner at Messing, Radowski, and Wellicke, tell me about this difference between settlement and agreement.
Well, this is reminding me of the Bill Clinton testifying at his deposition that he didn't have sex with Monica Lewinsky by his own sort of unique definition of what sex was. The words that Mr. Cain said may have meaning to him, but they don't have any, there's no legal distinction that he's making. What I understand happened in these cases is that a sum of money was paid to different women, or some different sums of money were paid to different women. That, in the normal course of events, what happens with that is that an agreement is signed where the person agrees not to sue, in this case, the National Restaurant Association and Mr. Cain, and they receive a sum of money for doing that. You can call it a settlement, you can call it agreement, you can call it a deal, you can call it a severance arrangement, but the legal character of it doesn't change by what you call it. Now, does that mean that the employer is admitting that the sexual harassment happened as claimed by the employee? Not necessarily. Does it mean, though, that it's unlikely that a sum of money would have been paid if some at least question hadn't been raised about what happened? It is certainly likely that the money wouldn't have been paid unless somebody thought the employer had some risk if they didn't pay the money.
That raises an interesting issue, Kent Greenfield. I mean, one of the questions here is how commonly do people pay out fairly large sums of money? We heard about an agreement that was $45,000. And you know, what if that's part of a severance package versus something to settle allegations? Put that in context for us.
Right. The economics of settlements are pretty nuanced and tricky. Whether you're on the plaintiff side or the defense side, you have to figure out what the probability of judgment is going to be, what the probability of spending a lot of money in court is going to be, and if you're on the if you're in the position of one of these employees that has been harassed, what's it worth to you just to let it all go away? You don't want your reputation dragged through the mud either by bringing this up. What Ellen was saying before, that these are courageous acts, is true. So it's not that unusual for settlements to be made, even if there's low probability of there being a judgment, but also it's not unusual for the plaintiff to agree to a settlement, even if there's a high probability of there being a legal judgment.
But the National Restaurant Association made multiple monetary settlements on behalf of Herman Cain. Is that normal that you would make multiple monetary settlements, but you wouldn't necessarily think the guy's actually doing anything to anybody?
When there's that much smoke, you would think that there's something of a fire.
Ellen, go ahead.
Yeah, I mean, I think so much of this has to do with company culture and with the power of the person who is alleged to commit the wrongful act. And what you generally see is the more powerful the person, the more the more payoff, the more cover up, the less sunlight there is in the situation, and the further the organization will go to make these payments as opposed to investigating the situation or cleaning it up. And so, in general, somebody who's at the highest level of an organization will tend to have a lot of ability to control their own tenure in office, and will keep themselves in power. And if that means making settlements or agreements to allow them to do that, that will happen. When somebody's lower down in the organization, coworker sexual harassment, first-level supervisor harassment, companies are often much more eager to investigate and clean up what they might see as an isolated problem. But once you have, corporate culture starts at the top, and if you have somebody at the top who is doing things that are improper, it's almost impossible for an organization to clean it up without a major overhaul of that organization. So you see people getting victimized and then more people getting victimized, and it never really goes away.
One of the interesting things about this Herman Cain press conference, despite the fact that there are multiple women who have allegations against him, is that he was really, really unequivocal. And one of the things he said, which I'd like to listen to for a second, is that he would be willing to take a lie detector test. And I want to go to you on Kent Greenfield after we listen to this and ask, what do you make of the fact that he is so sure that he doesn't either know these people or has never done these things that he would be willing to take a lie detector test? Let's listen to it.
Would you be willing to do a lie detector test to prove your honesty in something like this? Even though I'm sure, go ahead.
Yes, I absolutely would. But I'm not going to do that unless I have a good reason to do that. That was one of the first comments that I made in watching this to my staff. I've also shared that with my attorney. Of course, I would be willing to do a lie detector's test.
Kent Greenfield from Boston College Law School. Herman Cain here is unequivocal. What do you make of that?
Not much. The reason is because the culture around sexual harassment law has changed so much that especially someone during this time that these acts were alleged to occur, given someone of his age at the time, it wouldn't be that unusual for me to believe that would not be that hard for me to believe that he actually didn't understand that what was going on was problematic. That doesn't mean that that what he was doing was not in fact problematic, though. The sexual harassment was first recognized as a cause of action really in the mid-'70s. The EEOC in D.C. started recognizing and pushing regulations in the 80s. And then it really became central to our national discussion in the early 90s with Anita Hill, Clarence Thomas debacle. So it wouldn't be that unusual. It wouldn't be that hard for me to think that he just doesn't understand that what he was doing was problematic. And if he doesn't understand it, then of course he's going to pass a lie detector test.
Ellen Messing, is it possible? I mean, we heard Sharon Bialik say that he took her in a car, pulled over, and actually physically touched her. Is it possible that Herman Cain does not think that that's sexual harassment?
Well, there's a couple of things about that. I mean, first of all, lie detector tests are not considered very reliable or not admitted as evidence in most courts, partly because if you really believe or convince yourself you're telling the truth, you can pass a lie detector test regardless of whether you're lying. It's hard to know what's going on in Herman Cain's mind. In the cases that I handle, I do see over and over powerful people really not being able to wrap their brains around the notion that they could possibly do anything wrong. And they really believe it. It's very genuine. It's very sincere. If I did it and I'm the CEO, I'm the COO, I have a high-level position, by definition, it's okay, and because I'm, valuable and responsible, and these people aren't. And I think that the natural, as Kent said, the natural extension of that power dynamic is you really believe you can push around people who are below you on the chain. And it happens in many ways. Sexual harassment is one of them, and it's a particularly demeaning way. But if you really believe that, you're pretty much right no matter what you do, then you won't see anything you do to an employee as wrongful. And I think does he really internally believe that if he physically touched a subordinate employee that was morally or legally wrong? He probably doesn't believe that it happened in that way, or possibly he believes that it was her fault, which is the other major defense of sexual harassers. Whatever happened was the fault of the victim.
Ken Greenfield, I see you nodding there, that it is common that sexual harassers think it's the victim's
right,
problem.
or that it's welcome rather than unwelcome. Now, there's another interesting tie here. What Ellen was saying with the Penn State case. Humans tend to see the world around them, the facts around them, the world around them, to confirm what they already believe. So what Ellen was saying, right, that if you're a powerful person, you see the world around you, you see the reaction of your employees as confirming your power and their openness to your sexual advances. In the Penn State case, Joe Paterno did not see his assistant coach Sandusky as being a child rapist because he likes the guy. Sandusky is his friend, so he doesn't. The facts that would tend to belie that don't even rise to the level of cognition in Joe Paterno's mind because he sees the world to confirm what he already believes about the world.
Let's actually switch gears here and look at that, at the Joe Paterno case. Ellen, I have a question for you, and it's about what people are legally obligated to do. One of the ways that this whole story came to light was that this graduate assistant, Mike McQuarrie, reported witnessing Sandusky having sexual contact with a 10-year-old in the shower at Penn State. He told Joe Paterno the next day. Legally, what do you think Joe Paterno is obligated to do?
And as I understand it, Joe Paterno did report this to someone else at the university. I'm not sure who he reported it to.
He did. He told the athletic director.
Right. And I guess it died there.
I think the athletic director may not have told anybody, but at some point along the chain, it died. Certainly, Paterno may have known this by the fact that weeks and weeks went by and nothing happened. So if you see nothing happening, are you obligated to follow up or not really?
Yeah, there's a couple of things about that. I mean, first of all, the obligation of anybody in a supervisory position is to prevent and eliminate that sort of harassment, or in this case, I guess, abuse in this context, and particularly in the educational context. There is a legal obligation to do that. The responsibility, though, is that of the institution, and there's been so much focus on the responsibility of Mr. Paterno that it's almost as if the institutional responsibility is lost. These laws, the laws that apply to gender discrimination in education and to sexual misconduct and abuse in education, are laws directed to the behavior of institutions. Institutions are supposed to have a robust system for finding this stuff out and resolving it. And I guess the question I have to ask is, Mr. Paterno did something. And in fact, in a lot of these situations, people in his position don't even do that. He did something. He did report it. Why did the institution drop the ball? And why wasn't there anyone else who had some responsibility for making sure that an investigation was started into it at the time?
Kent Greenfield from BC Law School. We should clarify, obviously, that the allegations against Sandusky are just that right now. But is it your obligation to just tell a superior you don't need to deal with the legal community or with the police on this if you see something that's, legally actionable?
Right. I'm not sure what the law is in Pennsylvania, but it certainly seems that the moral obligation of Joe Paterno is to do something, right? As a parent, there's nothing more tragic or horrible to think about than to put your child in the care of some authority figure and have that authority figure misuse that authority. Of course, the timing of this was early 2000s. 2002 was apparently when the incident occurred with allegedly with Sandusky and the 10-year-old in the shower. That was about the same time that all the allegations were coming to light about the Catholic Church, and Joe Paterno was Catholic. So he would have been very aware of the problems of institutions shoving things like this under the rug and taking a blind eye to this. So I think it's if I may say, it's shameful for that Joe Paterno did not do more.
Ellen, one last question to you. Where do you see, obviously Paterno has said today that he is going to leave Penn State. Where do you see this case going? Is it going to get bigger, do you think?
I think so. I mean, as I understand, the trustees are launching an investigation into who knew what and when did they know it, which, again, it's always a good thing when there is some sunlight streamed into the institutional failure to take these concerns seriously. And I would hope that investigation would look at not just Mr. Paterno, not just Mr. Sandusky, but the whole organization. Did anyone ever tell the athletic director that there was someplace to go with this information? Did anyone tell that to Mr. Paterno? Was there any kind of training or awareness inculcated in the athletic department about what you do about this stuff when you hear about it? Did anyone take it seriously? And if not, how are they going to fix that so that this doesn't happen again?
We will follow this case. Ellen Messing, partner at Messing, Rudowski, and Willicke, PC, thank you so much for joining us.
Thank you.
And Boston Law School professor Kent Greenfield, you're actually going to stick around, and we are going to tackle some of the themes in your new book, The Myth of Choice. I'm Kara Miller, and you're listening to The Emily Rooney Show on WGBH. Stay with us.